You suffered horrible injuries as a result of getting hit in the rear while on the highway. And now the defense turns around and says, hey, don't blame me, I'm not at fault, the brakes failed. It's a mechanical problem and a mechanical defect. What happens if the defense gets rid of their car before we have an opportunity to inspect it? You want to learn what happens? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a personal injury car accident attorney practicing law here in the state of New York. So here's the scenario. You've been involved in a significant accident where you were hit in the rear. And now the defense, the careless driver, turns around and says, hey, I wasn't really at fault. My brakes failed. When I applied my foot on the brakes, they didn't work. So don't blame me. It's a mechanical problem, a defect from the manufacturer. Now, if in fact that's true, that raises a whole series of other problems. But now, we need an opportunity to go ahead and determine whether or not what the defense is claiming is actually true. So how do we do that? One of the best ways to do that is to have our own mechanical experts go and inspect the car. Now, what happens though if the defense has actually gone ahead and trashed the car, if they've totaled the car, if they sold it off and no longer have access to that? Well, that creates a big problem, because now we no longer have the ability to determine and test whether or not the claims made by the defense are in fact true. So now we're at a significant disadvantage. And now if the defense wants to come into court and claim, hey, listen, don't blame me, it's a problem with a defect, it's a problem with the brakes, well, guess what? Now we no longer have the ability to test that theory to determine whether or not what they're claiming is true. So then we would ask the court to dismiss that defense when we claim that there is a spoliation of evidence. Now, what does that mean? Spoliation of evidence is a fancy legal term that basically says, listen, that critical piece of evidence which would help us determine who is actually responsible for causing this accident is no longer available. And the defense knew or should have known that this piece of evidence was going to be critical in this particular case to determine who's liable. And because they got rid of it, because they knew about it, now they no longer have the benefit of using that defense, because that one critical piece of information which would give us the answer now is no longer available. There are instances where the court will tell the defense, listen, you got rid of that one piece of critical information that we needed, and because of that, you no longer can use that defense claiming that the brakes were defective. You know, chances are you have questions about your own particular matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.